The Judiciary Public Safety Conference Committee will come back to order. We are now going to present the Senate provisions that do not appear on the House side, so that you can have an opportunity to learn and to ask us questions. So Senator Pappas will go with you first, since you have a bonding committee to get.
Thank you, Mr. Chairman. Not till 4:30, so I'm not going to take up all that much time.
All right. You don't have to go first if you don't want to.
I can
All right, Senator Pappas.
gather my thoughts. I think
Senator Umu-Verbeten, what time do you have to leave?
I'm good.
You're good.
All right.
Senator Westland. You're good.
When you have, oh, you let her go first.
wanna
I
go
don't have
first?
to leave till 4:30.
You don't have anything? Okay.
Oh,
Nothing specific for you to present.
Law school flashbacks. Called on. I don't think I have.
Okay, you can't backbench it here. Senator Pappas.
Thank you, Mr. Chairman. And so I just wanted to chat for a few minutes about work release. And I think that the work release program is part of our overall strategy of second chance and getting people ready for reentry and reintegration back into the civilian world, if you will. And the thing that I really like about work release is that they're in halfway houses. So the housing is provided. And when we look at the affordable housing crisis, and that sometimes people may be estranged from their families and maybe sleeping on someone's couch isn't really ideal. And so part of that, they're still under supervision, but in the community, able to do education, able to get a job, help with a job, support for other services they may need, but especially that housing item, so that then the formerly incarcerated person can save up for a down payment on housing and kind of get their life more organized than they can do from prison. So I think it's really important. And, the original ask was like $15 million. And we have, I believe, $4 million in our bill because the commissioner basically said that's probably all they could really handle at this point. So I think it's a really reasonable ask. And I think it's very consistent. What I hope is our kind of a joint mission here is to assist with getting people back into society and successful. And I have just some data about the safety of work release. Less than 1 in 500 committed a felony while in the program from 10 years of DOC data. And that otherwise, a lot of times people will end up homeless. And so then it exacerbates our homeless problem. So I think that we can solve a lot of issues by continuing to have robust support for work release.
Any questions or inquiries? Chair Moller.
Thank you, Mr. Chair, and thank you, Senator Pappas. I agree with you, and I'm just trying to figure out where our differences are because we have, and I don't know what bill number you had. Maybe we can match it up. I'm not sure where.
Senate Bill 1504.
Okay.
And we think that Representative Finke was the House.
Oh,
author.
okay, right. So we do have, I think it must be a smaller amount than in our budget for that. We do have Representative Finke's bill, though, in our spreadsheet. And then there's also a separate bill that Representative Noor had, and that ended up in the Workforce and Labor omnibus bill. I think it was a $7 million, I can't recall.
Madam Co-Chair, I'm not seeing anything on the spreadsheet for, is it on a different line item?
Mr. Turner.
Mr. Chairman, the Senate position is on line 321. The House position is on line 367. The Senate funds it through institutions, and the House funds it through community services.
Great. So, Madam, that's wonderful. We're in agreement that it's an important program, just the level of funding. And then I was just talking with Representative Umu-Verbeten, and she thinks the NOR proposal is just for education. It's not actually for work. And education while you're still incarcerated. Is that what you want? The NOR proposal that's in labor? Were you talking about that? Oh, I'm sorry. I think Representative Feist was talking about that.
I was talking about that.
Sorry, you were standing together. Representative Weiss, is that what you recall?
Representative Weiss.
Yes. Representative Noor's bill had to do with programming while folks were incarcerated. And Representative Finke's bill was the work release bill that originally was at $15 million, and we included at a lower amount.
All right, Senator Pappas. Do you have another bill to present?
I don't know, do I?
That's it for you.
That's it for me. I
Okay.
don't see the agenda.
Thank you. Senator Verbatim.
Okay, thank you, Mr. Chair. I have Senate File 2495, which bars the use of intentional deception by law enforcement officers during interrogations. It makes that inadmissible in court. So this is just when folks knowingly communicate false evidence, misrepresent the accuracy of facts, or communicate unauthorized statements regarding leniency. And this is a leading cause of wrongful convictions. It's really psychologically disorienting for folks, especially young people. It is not a good look for building community trust, and it's just found to be ineffective. And Andrew Marquardt from the Great Innocence Project is here with us today too, if you'd like to speak to this more.
All right, Mr. Marquardt. Why don't you come on forward and give us a short explanation of what the bill does and the reasons for it.
Sure, Latz. Thank you. Andrew Marquardt from Great North Innocence Project. So as Senator Verbatim described, this bill would make inadmissible any statements coming out of police interrogations in which deception is used. Our chief concern at Innocence Project is with wrongful convictions, and the use of deception in combination with some other really powerful interrogation techniques can be one of the leading causes of false confessions. People ask, will people confess to things they didn't commit? Yes, they will. We know they will. There have been scores of DNA exonerations where people confess to things they didn't commit, and the use of deception has been shown to be one of the big drivers of this problem. So this bill presents a really clear rule, a really bright line rule, so police don't have to guess where the line is. If you engage in deceptive techniques as defined under the bill, then that confession is going to be in jeopardy. So police know where the line is. They know it is clear to apply, easy to follow, and it really only it comes into play when there's knowing use of deception. It's really important. So it's not going to be sort of something you fall into. It's not a foot fault. It's really the kind of deliberate use of deception that has no place in law enforcement. It's not an effective technique. We've talked to lots of police who say this is just bad policing, just bad tactics. And it really, deteriorates trust in law enforcement. So for all these reasons, I hope you'll support, and happy to stand by for any questions.
Any questions for Mr. Marquardt? Chair Moller.
Thank you, Mr. Chair. And, you and I talked about this towards the beginning of session. I know the language wasn't ready till a little bit later. And I think one of the concerns I have was I know that this would be first in the nation to be this broad of a restriction on interrogations. And I'm also really curious to know where law enforcement stands on this, particularly the BCA and those investigators. And I haven't heard back if you got any of that feedback. I'm also interested in the County Attorneys Association and where they would stand on that. So I'm just curious. I think what you're trying to do is good. I just worry that it hasn't been vetted enough with the stakeholders.
I can answer. Sorry. Thank you for the question, Chair Moller. So this did receive a letter of opposition from a coalition of law enforcement groups at the committee level, including the County Attorneys Association and others. So there has been some concern from certain law enforcement stakeholders. and one of the points of concern has been the one you articulated there, is that this bill would go a bit further than some other states have gone. The focus so far in other states has been largely around juveniles. There has been some move to look at pushing that beyond 18. I think Vermont just passed a bill that is up to 21. I think there would be principled bases for looking at 25 as a cutoff point, just based on the science of brain development, going with adolescence, going past 18 being a kind of arbitrary marker. But yes, this bill, obviously we think that it's justified, that many of the risks that come into play with young people, they may be at their sort of apex with young people. There are many people who are adults who may be less sophisticated, who may be more susceptible to manipulation as well, and that many of the same concerns would come into play there. But yes, this bill would go beyond what other states have done and would make us a leader on this issue.
Representative Feist.
Thank you. Thank you, Senator Verbaeten, I can't see around, for bringing this bill. I've introduced legislation on this topic as well, specifically pertaining to youth. And I do agree that it's a very important issue. I know that I had a lot of conversations last session with colleagues about my legislation that I'd be happy to share with you too, just making sure that it is fully vetted, and I have some additional thoughts that I'd be happy to share too. But I do think it is a really important issue. I think we need to really think very seriously about the use of interrogation, and whether it's something that we want here, or the use of deception in interrogation, and whether it's something that we want here in Minnesota. So thank you.
Representative Freed.
Thank you, Mr. Chair. And Senator, thank you for bringing this bill. Mr. Marquardt, thank you for being here to testify. You and I talked, too, about this bill and another bill early on in session. And I share the same type of support. I think this is going in the right direction. It's something that we really need to take a strong look at. I think about many of the wrongful convictions, I can't talk right now, wrongful convictions that we have that are ultimately overturned. And when you look back at those, it is often these deceptive practices that are in place. And I also look at, when you look at the data, the disproportionality of who those folks are that are put into our system and lose many years of their life because of that. And I'm always trying to focus on how do we disrupt these inequities that we have in our society from a systemic perspective. And I think this is something that could go towards fixing some of those. So I'm hoping we can continue to have this conversation and work out the pieces we need to work out and move forward.
You may not be able to talk, but you always speak with conviction.
Thank you, Chair.
Any other comments or questions? Representative Curran.
Thank you, Chair. And just to add on a bit with what Representative Frazier just said, that we do have to look at how this affects different communities in disparate ways. And there's folks know that when they go and interact with police now, that they can be lied to. And there's that leaves little room for incentive for folks to really try to preserve their place in the justice system when they really feel like walking in the door. They're just going to be lied to and manipulated in the first place. And so that really is a disservice, in my opinion, when we're trying to have a system, a clean justice system, that I think that does a disservice to the person who's being interrogated. And I would also add that, we look at different practices that we've had in law enforcement and whether something is a good tool or not. And this is something, too, that I come back to and see sort of as a constitutional issue as well. That it's hard for me to see, deception, intentional deception and manipulation as something that, we could say is within the scope or within your constitutional rights of, fair due process of law. I struggle with that as well. And so, those are a couple of the reasons why I really support this provision. I really support this bill. And I'll close too in saying that we have a real opportunity with a lot of sections of this bill to repair some of the relationships between police and the community. And I think this speaks to trust, in that there are folks who know how the system works and knows that they can be lied to. And I think if we, can remove even one reason why folks can, immediately distrust, if we can kind of place that back, people know that they can go into a process that is just and honest. I think that's a good place to start when we're repairing relationships.
Anyone else have any comments to make? Senator Seeberger, would you like to talk about the carjacking provision?
Thank you, Chair Latz.
Members, you can find the language in the unofficial engrossment of Senate File 1267 at page 27, I believe. Yes, page 27.
My bill establishes crime of carjacking. Up until now, there really hasn't been anything designated as carjacking, and what this does is simply takes what was charged out prior as simple and aggravated burglary crimes and specifies it as a carjacking offense. This kind of fits together with a bill offered by Senator Limmer to speak to data with regard to carjacking. And I know that even in terms of my district, it's something that I know that law enforcement has asked for.
Senator Seeberger, I'm going to interrupt for a moment. There are two carjacking provisions in the bill. The one she's describing right now is at page 49. Go ahead, Senator.
All right. The bill establishes first degree carjacking, which encompasses the act while armed with a dangerous weapon or any article used or fashioned in a manner to lead the victim to reasonably believe it's a dangerous weapon, and establishes penalties of up to 20 years and a fine of $35,000. Second degree implies possession of a dangerous weapon with up to 15 years and a $30,000 penalty. Third degree carjacking under any other circumstances, 10 years and a $20,000 penalty. It simply knits together the criminal penalties that we already have to establish this particular offense.
Any questions or comments from the committee? Chair Moller.
Thank you, Mr. Chair. And I had seen different versions of this in the past. So it is in your policy bill, so I assume that means there's no fiscal note with this, because you're assuming that people who are already charged for some of those other offenses would then get moved over into these charges. Is that correct?
Senator Seeberger.
Mr. Chair, that's my understanding, yes.
Okay. And then I just was curious if any groups, I know when I had started looking into this issue a couple of years ago, I had heard from county attorneys that they felt like they had the right tools already, because they can charge some of these cases out as assaults, robberies, simple and aggravated robbery, and I'm assuming that's mirroring this. And so if you could just speak to that, maybe the need, in your opinion, for this in light of the fact that we do have some of those other charges available.
Senator Seeberger.
Thank you, Mr. Chair. Right. Well, I guess I'm going to start with the opposite. The pushback that I've heard is from some stakeholders and legislators who don't think the penalties are high enough. And I think that the way that we've crafted this is the appropriate way to structure the various degrees of the offense. in terms of specific stakeholders, county attorneys, law enforcement, I've heard it more at the grassroots level from law enforcement agencies in my community, that this is something that they would like. It doesn't necessarily alter the tools that they have at their disposal, but certainly does give them this particular avenue to call the crime what it is, essentially. And so it has support in that regard.
Senator Seeberger, the prohibition against retaliation on page 27.
Yes, thank you, Mr. Chair. So this is a bill that I brought early on in the session and picks up where the work was begun in 2020. In 2020, the legislature passed a law imposing a duty to report any and intercede in the use of excessive force as a part of the police reform package following the murder of George Floyd. This particular bill goes a little further and prohibits retaliation against law enforcement officers who do report this use of excessive force or do intercede in the use of excessive force. The retaliation includes firing, disciplining, threatening, general retaliation, discrimination, or penalizing a law enforcement officer who does step forward under this duty. And it's prohibited by other officers and their employers. So it also provides for a civil action if retaliation is engaged in.
Any questions or comments? I gotta try to remember my own bills. Where am I going? So we're going to go to one of my bills now on ignition interlock. I'll start on the Senate File 1824, page 3. So that's the first part of it, but there are several components. Page 6, I guess, is the next part. There are several components to this. Under certain circumstances, when you're arrested for a repeat DWI, there's a mandatory hold for court, and release is available under with two options. One is to post $12,000 mandatory bail, or alternatively conditional release, which includes an abstinence from use of alcohol condition and electronic alcohol monitoring to verify that you're maintaining your abstinence. With the advent of the ignition interlock system for driving a vehicle, which also monitors alcohol use or verifies abstinence of it, the purpose of this provision is to give use of the interlock as an alternative conditional release, so that a person can be released using interlock and not have to pay separately or use separately a portable alcohol monitoring system. It provides that that can be available immediately upon the conditional release, but as a practical matter, that's highly unlikely because no one has had a chance yet to install the interlock in their vehicle within a day or two of being arrested for DWI. So it also provides that that conditional release with the electronic alcohol monitoring can be modified by a court at a subsequent proceeding, so they can switch it out, basically. If they get interlock installed, then they can turn back in the portable alcohol monitor and can rely only on the interlock. The interlock systems do require that that people blow into the device at least, I think it's 30 times a month. And it might even be one time a day, I'm not sure, but it's pretty frequently. So if it's good enough, as far as I'm concerned, if it's good enough to verify that they're not drinking alcohol and getting behind the wheel, which is the main purpose of the public safety here, then it ought to be good enough to be as a mandatory, as a condition of release from custody on a DWI offense. It will also save them money in the process. The other component to the ignition interlock legislation is to basically prohibit steering to particular interlock providers. It has become apparent in some circumstances that probation officers or counties that have contracts with certain interlock providers are essentially recommending that someone who is about to be released go use one particular interlock provider, and has the effect of freezing out the other 6 certified interlock providers in the state of Minnesota. Some counties do have a contract with a particular provider when they are subventing the cost for those who are indigent or who are financially or income qualified for subsidies for interlock. If the county is helping that out, there's an exception there. For that, the county is still entitled to have the contract. But if they're going to give information on particular interlock providers, they'd be required to give contact information for all of the certified interlock providers in the state, and then the potential customer can do their own, make their own decision about which provider to go to. So that's basically the interlock provisions. Representative Feist.
Yep. Thank you. I'm the House author of this, and I think it's a really good bill. I think the conditional release provisions make a lot of sense, and I especially like the provision that would get rid of some of the anti-competitiveness in the current situation. So I support this bill.
Chair Moller.
Thank you, Mr. Chair. And I was just curious, there's something about the policy that I dislike, but I was just curious about, I know for ignition interlock, we've had some conversations before, not necessarily you and I, but just with stakeholders in general about use of interlock for cases involving alcohol impaired driving versus drug impaired driving. And I know our statutes maybe could do a better job of sort of parsing out those two situations. So I don't know if this, anything in your language kind of helps parse that out, or if it's just the blanket ignition interlock for anybody who has one of these driving offenses.
The language doesn't make any changes with regard to who would be eligible for interlock. So I agree with you that that's an issue. And honestly, we don't have an interlock device right now that would be specific to controlled substances, only to alcohol. So it's an imperfect solution there. I think in the CVO statutes, if I remember correctly, there are some distinctions made there, but not in the general driving while impaired statutes. And it's something we do need to address. I'm not sure if the technology is quite there yet, but it's worth looking at if we can figure that out. I think some of the explanation initially when this was first passed was that there's a lot of co-occurrence between drug use and alcohol use as well. Not a perfect overlap, of course, but the idea was that people are at least safer if they're using interlock than if they're not. And of course, part of the concern is that people who are unrestricted driving privileges, they tend to drive anyway, whether we tell them they can drive or we tell them they can't drive. So at least if they can get in there lawfully with interlock, the public is safer than otherwise. But I agree with you, it's a concern, and hopefully sometime the technology and the statutes can be matched up.
Yeah, Mr. Chairman.
Chair Moller.
Yeah, and even outside of that, I think if we do something like what you're proposing this year, but can continue to work on that perhaps sort of separation next year, because I do know that we have a member who's talked about her own brother having substance use disorder, and it's not been alcohol related, and some of the restrictions that have applied for him are really based on alcohol, and they just don't make a lot of sense for his situation. And so I'm, definitely committed to working on that even next year, if that's something that we could look at.
Bless you.
We'll do work with you on that, I agree. Representative Frazier.
Chair Latz, just a point of clarification. You mentioned the number of times someone would have to blow into the system. Is it? I was under the understanding that you have to blow into it every time you actually drove the vehicle. Is that not correct?
Representative Frazier, we're going back to the terms of the interlock program itself, which
Okay.
are not specified in the bill, but yes, that is true. There are multiple requirements, and someone from the department is here might correct me on some of the specifics, but yes, you are required to drive only the vehicle that is outfitted with the interlock device.
Right.
And in order to start the vehicle, you have to blow into the device and blow zeros on alcohol concentration. And then once the vehicle starts, there are rolling retests. So you have to continue to blow zeros as you're driving the vehicle in order
Okay.
to continue driving the vehicle. Now, the engine doesn't die in the middle of the road, but when you pull over and stop, it won't start again.
Okay.
And it will give you also, if you blow up to a .02, you won't be able to start the vehicle, but it will flag it 02 or higher. It will flag it as well. In addition to that, I believe there's a requirement that there be a certain minimum number of tests every month, which I'm not sure if it says it's got to be at least once a day, but most people drive frequently enough
Right.
that the idea is it would cover as much territory as we possibly can. I think it's 30 times a month. I might be a little bit off on that.
Thanks for the clarity.
All right. Okay, Senate File 200, you also have a bill in front of you. Mr. Marquardt, we're going to turn to the post-conviction relief provisions. New standards for newly discovered evidence. Is that an Innocence Project initiative? I believe it was. Yeah, if you want to come down. And Senators Weston and Verbatim were both co-authors on this bill. What page are you on? Page 27 on the Senate File 200. This makes some modifications to petitions for post-conviction relief based on newly discovered evidence. Mr. Marquardt, maybe you can explain some more detail.
Sure. Again, Andrew Marquardt. I'm a managing attorney at Great North Innocence Project. So this bill concerns the way the statute of limitations works for a post-conviction claim based on newly discovered evidence. So under the current law, there's a presumptive 2-year statute of limitations. So your conviction has become final. You generally have 2 years to file a post-conviction claim to try and get it overturned. There are certain exceptions. One of those is for claims based on newly discovered evidence. The problem from our perspective is the standard here is just too high. And it's much higher than most states. It's the highest standard in the Midwest. And the real rub here is that just to get back into court with a claim based on newly discovered evidence, not to go home, just to get back into court, you have to affirmatively prove your innocence by a very high, clear, and convincing standard. And that works for some cases. If you have DNA, that sort of works. You know, if it's an identity case and you have DNA, you can prove that. But most cases don't have DNA. And in most cases, clearing that bar is almost impossible. And what that means is if you have new evidence, and under this statute, and we would be keeping this, it has to be evidence that could not have been discovered previously with due diligence. In other words, it's not your fault that this is coming up late, but it's new evidence that provides the factual predicate for a claim. So in other words, you have facts that are new, you couldn't have discovered them previously, and they provide a claim that your conviction is factually and or legally defective. Under this bill, you would get a chance to go into court and prove your case. Now, you still got to prove your case, but you get that chance, and right now you don't. So that's what this bill changes. It's not going to result in a flood of litigation. I know prosecutors are very concerned, and with some reason, about pro se litigants filing lots of motions. The reality is right now they file those things anyway. They're going to file them no matter what the standard is. The real question is how many of those are getting into evidentiary hearings, which essentially are like trials where the really big burden comes into play. And if you look at these cases, overwhelmingly, these pro se litigants, their cases are getting thrown out on 4 or 5 grounds. This is not the only reason they're getting thrown out. So those claims are still not going to be proceeding. The ones that are going to get through are the really meritorious claims, the claims where someone has a real case that their conviction is defective, and the claims they should get through, and the ones that are getting left out in the cold right now, and where people who are wrongfully convicted have no opportunity for relief in Minnesota. So that's what this bill does, and happy to answer any questions.
Chair Moller.
Thank you, Mr. Chair. And again, similarly with the other bill that the Innocence Project had, you and I discussed this, and I said I really wanted to know what the County Attorneys Association, how they felt about this, because I know in the past they've wanted to make changes to the post-conviction statutes that haven't been made, and I've never heard back that conversation took place. I also let people know I talked about being a prosecutor. Well, I handle felony appeals, and I've done that work for over 20 years, and we do get a lot of post-conviction claims. The default is often for a hearing in certain cases. And so to just say, oh, these pro se litigants do that all the time, it's not a big deal. It is a big deal. So I don't want to minimize that. But I'm just curious to know what you think about, or if you talk to the County Attorneys Association about this proposal.
Mr. Marco.
Thank you, Senator Latz, and thank you for the question, Chair Moller. I have had conversations with the County Attorneys Association and a number of individual prosecutors. I've received, some questions. We've had some conversations. To my knowledge, I'm not aware of the association taking a position on this bill. And could I offer one point of clarification? I certainly didn't mean to suggest that pro se litigation is not an issue. I simply meant to express that I don't think this should make whatever problems exist greater than they currently are.
Any other questions? Representative Frazier.
Thank you, Chair Latz. I'm the author on the House side, and we didn't get a chance to hear this bill. I think largely because we ran out of time, but I also have spoken with my chair, and I know what her concerns are. And so my hope is, because I think, again, this is something that's going in the right direction in terms of creating some fairness within our system, is that we can have those conversations and continue to work towards this and get it moving forward. So thank you.
We're going to go now to page 4 and 5 on the same bill, Senate File 200. We'll address some confidentiality provisions. This was Senator Limmer's Senate File 2913, addressing
You're fine, sir.
okay. Addressing the accessibility of personal information for judges
Page 4.
and other judicial officials. So it basically makes that information not public. It also provides that attorneys would have access to court records electronically through the Minnesota Government Access System. Right now, lawyers, even for their own clients, have to go in through the public systems in MNCIS or MCRO and only have access to the documents that are public in there. Can't access the not public documents even for their own cases. So it would provide a system for attorneys to be able to go into the MGA system that all the prosecutors and probation departments already have full access to. It gets a little awkward sometimes having, as a private defense attorney, to ask the prosecutor for documents in your own case that are otherwise accessible. So this would end up probably saving the prosecutors some time responding to those requests. If you look at Section 8 on page 5, that also further addresses dissemination of personal information and makes clear that it is a crime to disseminate personal information for judicial officials as well as for family or household members related to law enforcement. Any questions about that or comments? Chair Moller.
Thank you, Mr. Chair. I will say, as someone who uses the Minnesota Government Access account, it is very helpful, so I could see where that would be useful. My questions, or maybe just comments, are more related to the judicial personal information piece of it. I know this proposal came in pretty late, and I know Chair Becker-Finn and I both support what it's trying to do, and when we talked to stakeholders, we asked for an opinion from MinCoG on what their thoughts were, and I know they had some suggestions for that, and I don't know if those have been incorporated in this language. So when we got that information back from MinCoG, we decided to just press pause on it and not have a hearing on it this year, but work on it for next year. And I thought the stakeholders were in agreement with that, but don't know if that maybe you've incorporated those suggestions already.
Ms. Primo, do you have any idea of MinCoG's involvement in this bill? It was Senator Limmer's bill, and so he may have talked with them before that, which we don't know offhand.
Mr. Chair and members, there was a DE, the work is a reflection of the DE adopted by the Senate Judiciary Committee. I am having a hard time right now recalling who was involved when I drafted that. I can look through my email and update the committee members.
Any other questions or comments? Okay. We'll now turn to Senate File 1267, page 54. This is another Senator Limmer bill involving swatting or falsely reporting an emergency. So there's already a crime to do that, which is a 10-year felony. But it was the judgment of our committee that there was a lot of space between great bodily harm or death, which is covered as a crime, and no impact at all. So we added a 3-year felony if a fictitious emergency call triggered a response and resulted in someone suffering substantial bodily harm. Questions? Chair Moller.
Thank you, Mr. Chair. So there's not a fiscal note on this one then? Or no cost, I guess I should say.
No.
Thank you.
So at this point, we don't have anything else to present. There might be some other bills that are Senate only, but we need to have staff have a chance to go through and complete or continue working on side-by-sides as well. So unless there are any further questions or comments, I'm inclined to finish our work for today. Senator Pappas.
Thank you, Mr. Chairman and Representative Moller. I don't think Maybe it is. Given the amount of work that needs to be done by the reviser, it's been suggested that to the extent possible that we do try to approve sames and similars, maybe complete articles, so they can be sent to the reviser's office, and we don't leave everything till the end when there's going to be a big crunch by the end of the week. So just wanted to suggest that in your planning for what we're going to do, that we just be conscious of how much work the revisers have to do.
Thank you, Senator Pappas. Chair Moller, would you like to give us a preview of what to expect tomorrow?
Thank you, Mr. Chair. And first, I agree with Senator Pappas, too. We will try to strive to get those same and similars, I think, completed early so that we can focus on the things where we have areas of difference. Tomorrow, we are planning on staff doing a walkthrough of the spreadsheets and highlighting the differences between our two bills. I think we're probably going to be in session late morning, so we're not going to have a ton of time, at least when we start at 10, to go to that. And then is there anything else? Yeah, I think that's mainly our focus tomorrow, is to walk through the spreadsheet. Thank you.
All right, not seeing any other members interested in jumping to the mic for today. We are adjourned.